Item number 1 to 15.
May it please, Your Lordship. Item 1 to 15, my lord, are against the order of learned single judge, whereby learned single judge has held that the work charge implies are also entitled to and covered by recommendation of Fifth Pay Commission.
The who?
Work charged employee, the employees of work charge establishment are also covered by the recommendation of Fifth Pay Commission, and the service rules, pay rules will apply to them.
What is work charge?
Work charge establishments are establishment, they are for limited period. For example, my lord, if there is a road to be constructed for 10 kilometers.
Ad hoc purpose.
Ad hoc purpose. So they are called, a specific term, a legal term has been coined and used, is a work charge. So the legal issue is this, but today, my lord, the issue before your lordship is that there are delays in filing the petitions, my lord, and my friend has filed the so-called opposing the condonation of delay. In the matters, because there are about 314 petitioners before the learned single judge in 15 matters, my lord.
What has the learned single judge held?
Learned single judge has held that the statutory rules relating to the regular employees will prevail, and the employees, ad hoc employees, are also covered by the recommendation of Fifth Pay Commission. That is one finding of the learned single judge. Second finding of learned single judge is, my lord, that the statutory rules will prevail over executive instruction, because by executive instruction certain clarifications were issued in pursuance to the power conferred.
So what benefits are they seeking?
They are asking for regular pay scale and the benefits which are admissible to the regular employees of the government, my lord. So this is
after learned advocate general, after the work is over, the designated work, say construction of a short bridge.
Yes, my lord.
If it is over, say, in 8 months.
Yes, my lord.
Then how are these employees placed?
In the facts of these cases, my lord, there are certain work charge establishments which have been going on for quite number of years, my lord. The work is still going on; it is not over. And admitted case of the petitioners are that they are employees of work charge establishments.
No, they are recruited for this purpose.
They are recruited for those establishments only, my lord. Work charge establishment.
Not that they are drawn from the regular service.
Yes, they are not drawn from the regular service. So this is a legal issue which your lordship will have to look into and go and examine it. Certain rulings or judgments are in my favor. Certain judgments they will be citing, my lord. So this is an important legal question which needs to be decided by this.
So your case must be that they are kind of tenure contracts.
They are tenure contract, and they are not covered under the recommendation of Pay Commission, and they are also not covered under the rules framed under Article 309 of the Constitution of India. But today, my lord, these 15 matters are for condonation of delay, my lord, all 15 matters.
What is the number of days delay?
One is 111 days, my lord. In the first matter is 111 days because there were about 304 petitioners before the learned single judge, and the details and everything required collection and collation. It took some time, my lord. The order of the learned single judge is, my lord, of date.
These condonation of delay petitions are ready for hearing?
Yes, my lord.
Affidavits filed?
Yes, my lord.
Let us consider one.
Yes, my lord. The judgment of the learned single judge, my lord, is of 11th July 2024.
That will come later. Let us see the
grounds which have been urged in this, my lord, that the usual thing, my lord, that there was a certain holidays opinion from the law department, my lord, and entire process took some time, my lord. Paragraph 4 and 5 of my application, my lord.
application.
It's not used, delayed, not mollified.
Eleven 2024 is the
Yes, 11/7/2024, and the writ appeal was filed on 23rd November 2024, my lord. And in the reply, my lord, my friend has stated in paragraph 7. First English term. That there was a holiday for about 10 days only, and because what I was told that they have applied for certified copies, there was some time taken by them in applying.
But this application is very bold.
Application is very bold, my lord. But in these, your lordship, in for just cause and sufficient reason, my lord.
Have you made this up in your reply, or reply is also?
A reply is by the reply. They have said that.
So your reply?
To,
Your reply to the opposition?
no rejoinder we have not filed, my lord. We will file rejoinder, my lord, in these matters, giving details when did we apply for certified copy, because it took some time, because we applied for certified copy once opinion was obtained, and it took some time also, my lord. But delays are 111 days. If lordship will examine the matter on merit and once and for all, matter issue can be decided.
Learned counsel,
My lord.
even if we dismiss the application,
My lord.
the Supreme Court will say that you hear it on merits. So why don't we?
My lord, our only case is that, my lord, no reasons have been assigned for the delay.
That is all right.
Number one. Number two, my lord, these petitions have been filed after we filed contempt petition, my lord. In some of the petitioners, they have filed contempt petition, my lord. While these contempt petitions were pending, thereafter the writ appeals were filed, my lord.
You consider we will not force you,
My lord.
but it will.
My lord, we leave it to my lord's discretion, my lord. Our only contention is that, my lord,
It
at least for
will expedite final decision on merits,
My lord.
on the issue. Otherwise, this delay is dismissal of the appeal on technical ground. It will surely go to the Supreme Court. Again, it will come back.
My lord,
Again adjudication, again appeal.
if I may submit, my lord, even on merits, my lord, the case, the point of consideration that arose before the learned single judge was whether an executive instruction can override statutory provisions of rules frame under the Article 309. My lord, what happened was that the recommendations of the Fifth Pay Commission was accepted by the government. Thereafter, the Meghalaya pay revision rules 2018 were framed. Now, sub-rule 2 says that the benefits of the Fifth Pay Commission will be extended to all employees, including work charge employees. Now, my lord, they have been work charge employees for a very long period of time. The rules provided that the benefits of the Fifth Pay revision will be made available to these employees. Now, by an executive instruction, it was said that only work charge employees who were appointed prior in time, that is before 12/7/1997, will get the benefits of the Fifth Pay Commission. Now, my lord, the Fifth Pay Commission rules were made effective with effect from the 1st of January 2017. We received certain benefits, my lord. Thereafter, abruptly, it was withdrawn based on this executive instruction, my lord. So the matter that was argued before
the Pay Commission recommendation is also executive instruction.
My lord, not the recommendation, my lord. After the recommendation, rules were framed, my lord. My lord, these rules are at page 115, annexure A4 of the writ appeal, my lord.
On the merit of the matter, my lord. On the merit of the matter, my lord, your lordship may have
Rules under exercise of what power?
Exercised under Article 309 of the Constitution of India, my lord. These are statutory rules. So, my lord, these rules categorically provide that categories of government employees to whom the rules shall apply, save as otherwise provided by or under these rules. These rules shall apply to persons appointed in the civil services and post in connection with the affairs of the state of Meghalaya, including persons in the work charge establishment holding posts carrying identical scales of pay as admissible to the corresponding categories of regular establishment. Now, my lord, this...
All right, since you are opposing the Section 5 application,
my lord,
let them file a rejoinder.
or
Otherwise, we would have allowed it and expedited hearing of the appeal.
my lord, on the condonation application, will say that we leave it to my lord's discretion, my lord. My lord may condone the delay and the matter may be taken up on merits, my lord. As my lord has rightly pointed out. Knowledge.
We record with appreciation the fairness shown by learned counsel for the respondents. Full stop. Paragraph. There is no denial that the explanation of delay in the Section 5 application is not sufficient. Paragraph. Nevertheless, the state of Meghalaya is involved as the appellant. Full stop. A very substantial and important issue is as an issue is the subject matter of the writ and the appeal, namely whether the recommendation of the pay commission would apply to what work
charged.
work charged
Work charge establishment.
employees of the work charged establishments of the state. Full stop. The learned single judge by the impugned judgment and order has held that it would be applicable to all the employees, whereas according to the state, it has limited application.
yes, my lord.
Paragraph. Dismissal of the appeal on the ground of delay would result in disposal of the appeal on a technical ground, leaving the substantive issue undecided. Paragraph. considering the above and also bearing in mind the most reasonable stand taken by learned counsel for the respondents, we condone the delay. Paragraph, the Section 5 application is allowed. We direct the registry to register the appeal. The respondents are appearing, all the respondents.
Yes, my lord.
Then MC so and so is disposed of. Then you give the number of the appeal. The appeal is formally admitted. Next, as the respondents are represented through learned counsel, we dispense with service of notice. Next, we expedite hearing of the appeal. Advocate on record. For the appellant shall prepare and file an informal paper book in this court by June 12th.
June 12. In
One paper book should cover all the appeals.
yes, my lord. In the lead matter or whatever is convenient to my friend, I will file it. I will get it filed. One paper book, because the issue is common in all the matters. Legal issue is also.
This order is in the lead matter.
Yes, lead matter. I will.
It's a common judgment.
Common judgment about it. Anvil Star, Marvin versus 17 others is the lead matter. My lord. We will file.
Serving a copy thereof on advocate on record for the respondents at least 7 days before hearing of the appeal. List the appeal. List the appeals for hearing. On 24th June. Till disposal of the appeal or until further order, the respondents shall not take any further steps in the contempt application.
Grateful, my lord.
This is MC 78 and WA 78. WA 78. Okay. Then below that, yes, WA so and so, MC so and so, WA so and so, WA so and so, and you say that. No, and you also write that. No, in the cause title you give all the cause title, and then you write this. First, you write this order is passed in each of the above appeals and applications. All right. Then, last, each of the miscellaneous applications are allowed, is allowed, etc., etc. And one line you add, only one paper book may be filed. Now, the paper book in
We'll start.
The first one, WA
WA 78.
78.
78 shall cover all the appeals. We will hear it out.
Yes,
Certainly.
My lord, if I may point out one defect in the appeal, my lord. The parties, my lord, there's misjoinder of parties. It is not as per the writ petition, my lord.
We'll correct. We'll.
Mr. Advocate General, this is happening in some matters. If your junior who is preparing the appeal
Yes, my lord.
is leaving out some parties,
We'll check, and if there is some parties.
like in that Meghalaya, that tower matter, mobile matter,
Yes, my lord.
the state was made the appellant,
Yes, my lord.
or the distribution company of the state was left out. Whereas in the writ, both were parties.
Yes, both.
So the parties have to remain the
in
same.
pro forma responding. The state should have been in pro forma responding in that matter. Yes, my lord. Memo parties have to be same throughout.
Then we admit the appeal, leave is granted to advocate on record for the appellant. To rectify the cost title in the memorandum of appeal.
If required, my lord, if needed, because what my friend is saying that she has checked it from the order, but we will check it if there is required.
My lord.
No, are you sure or you're not
Yes,
sure?
yes, my lord.
You point out the problem.
My lord, may kindly have the impugned order also, my lord, because impugned order contains the entire.
All the parties are not there.
No, my lord.
That's all. By
So you have not made them party.
26 May and serve a copy of the
What about
amended cost title on the respondents.
They meet only the state of Meghalaya.
Number 16.
16.
Please, Lordship. As per the last order date 24 February 2025, we have filed the affidavit of service. The private respondent number 3 and 4, they have received the affidavit of that notice, Lordship. To that effect, we have filed the affidavit of service, bringing out record that they have received the notice.
What is this MC for?
This is actually for continuation of delay. Actually, the rare delay was only 11 days, but actually there is a pendency is because of we have filed the appeal, then after filing the appeal, then review, because the section 14 of the Limitation Act will protect us, because that the real delay is only 11 days. Or the other delays because of that we have been proceeding. First we filed an appeal, then appeal was they're directed to file a review, then we filed a review, then review was dismissed. Now we are challenging against the order of,
According to them, what is the delay?
yes, Lordship.
According to them, what is the delay?
Delay is only actually including all the this one pending in the court division bench in the this one, there is 350 days. 350 days, my lord. Yes, happened here. 350 days. But that is during the pendency of the division bench as well as in the single bench while filing of the review as well as in the appeal. That is, it is caused by that pending is caused due to the pending in the division bench as well as in the single bench. But actual delay is only 11 days, my lord. I have clearly mentioned in para 3 of my.
Yes, Mr. Chudai.
Lordship, let the matter be heard on merit, Your Lordship. So far, a condemnation, I would not oppose much, Your Lordship.
Mr. Chudai, learned additional advocate general. Has taken a very fair stand in this matter. Full stop. We have also perused the petition. Full stop. We observed that there was no culpable neglect on the part of the appellant, but inadvertent errors in proceeding with the appeal, comma, for example, choosing a wrong forum. You had filed it in the wrong forum.
It's not wrong point, but our appeal, they have said that you there was a direction. First, we file an appeal, then they said you file a review. There was a direction from this division bench to file a review. Then we file a review was dismissed. Again, then we are coming back. Actually, this is not wrong point. Earlier, we have challenged the appeal on. We have closely ordered lordship. It is there. First, division bench order is the lordship, that is in the annexure 1.
Wrong, for example, wrong legal advice and so on. We condone the delay and allow the Section 5 application. MC so and so is disposed of. We admit the appeal.
Lordship, so far the admission of the appeal, if I may pray, Your Lordship, because the point of maintainability also, I would like to raise the maintainability of the appeal, Your Lordship, because what happened, Your Lordship, there were 7 writ petitions, only a single appeal has been filed, Your Lordship. Before the learned single judge, it is a common judgment, Your Lordship, there were 7 writ petitions, Your Lordship. Here only the one writ appeal has been filed, Your Lordship.
No, Lordship, I will satisfy the court.
There was
Why I have chosen to file?
There was also a direction by the learned single judge, Your Lordship, to register a criminal prosecution against the writ appellant, Your Lordship, because
come at that time
to file
of
the
hearing.
writ petition before the learned.
But there is only one appellant.
Yes, only one appellant. Even the writ appeal also is
7. He was also
There is
a
a-
party. He was also a party in other writ petition, Your Lordship.
No, Your Lordship, I will satisfy at the time of hearing, Your Lordship. Now we are in the miss case. Let
All
it
right,
come.
this appeal is admitted subject to the question of maintainability.
Lordship.
Lordship.
Then respondent appearing, you will order as in the last matter, as in the previous matter. Paper book by 12 June for hearing on 20. This matter 26 June.
Lordship.
Lordship. Highly obliged.
Much less, Lordship.
Number 17.
Yes, Mr. Shah.
Matter item number 17 is the contempt matter. 18 is the appeal. Your lordships are pleased to observe that lordships will be hearing out the appeal itself.
Yes.
Well, the appeal is against an order dismissing my application filed under Section 9 of the Arbitration and Conciliation Act 1996. Let me address your lordships on the appeal. The contempt matter will not be incidental to under the whole issue. Well, we have filed informal paper books. Well, if your lordship will kindly take up, well, at page 32. Well, this all started with a memorandum of understanding of 21st June 2019. Global as an entity. Well, if I may draw your lordship's attention, well, to the memorandum on just 2 or 3 clauses. I don't think I need to trouble your lordships. Well, this was a memorandum of understanding entered into between a joint venture. Well, it was an LLP joint venture, well, which was described as the private partner, and the Department of Health and Family Welfare of the Government of Meghalaya. The idea was to establish the state-of-the-art diagnostic center for the people of Meghalaya.
Which page you are reading, Mr. Shah?
I am drawing your lordship's attention to the paper book at page 32. Since the paper book has been filed, I am referring to the paper book pages. May I request your lordships to please have a look at the purpose very clearly stated. If your lordship sees the background, which is the second page of the MOU, this was the object with which the MOU was entered into. The Department of Health and Family Welfare, Government of Meghalaya, intends to build state-of-the-art diagnostic center and facilitate improvement of health facilities for the people of Meghalaya. DH and FW is desirous of extending the benefit in collaboration with a reputed player having experience in the field. That is where, we come in. We are now the private partners. Now, your lordship will find that an issue has been made with regard to the description of the private partner, which has been mentioned at the top of the MOU as Suraksha Salvia Global LLP. Now, the LLP that was constituted was between Suraksha, which is an independent entity, and there's an entity called Salvia Global. If your lordship now comes to the bottom of the MOU, lordship will find that this has been signed on behalf of Salvia Global as one of the partners of the LLP, which is Suraksha Salvia LLP. Now, if your lordship will kindly have a look at, for example, page 70.
Page 123. 123 paper.
At page 1 to 23 of the paper book, this is the LLP agreement. Two LLP partners are Suraksha Specialty LLP and Salvia Global LLP. And if your lordships will kindly turn to page 72, the entity that was created was Suraksha Salvia LLP.
72.
I'm sorry. This is. You're looking at the appeal. This is paper book page. Paper book page 1, 2, 3, and 4. I'm sorry. Show me the paper book. If your lordship will kindly come to pages. Page 4 of the paper book, or page 1 of the paper book first again. The two partners of the petitioner LLP are Suraksha Specialty, that's at page 1, and Salvia Global LLP. These are the two partners that your lordship will find from page 1. Now, the entity that they establish is Suraksha Salvia LLP, that your lordships will find at page 4. Now, all the returns that have been filed My lord, because my lord, a limited liability partnership is required to be registered with the registrar of companies. All the returns have been filed by Suraksha Salvi LLP. I shall take your lordship through documents only if necessary. But my lord, for the time being, your lordship will kindly, my lord, see the constituent document. Two entities come together to form the petition of Suraksha Salvi LLP. Now, inadvertently, my lord, what has happened? My lord, if your lordship sees the memorandum of understanding, my lord, which is at page 32 of the paper book, well, it has been inadvertently mentioned that this is entered into between Suraksha Salvia Global LLP. Well, there is no such entity, my lord, in legal existence. Suraksha Salvia Global LLP and the Department of Health and Family Welfare. Now, my lord, coming to some of the clauses of this, my lord, agreement, please see clause Roman 5. My lord, which your lordships will find at page 36. I'm grateful to my lord. My lord, period of agreement at the top of page 36. The agreement will be for a period of 10 years and subject to renewal as per mutual consent. So 10 years from, my lord, 2019, because the MOU is dated 21st June 2019, which takes us to 2029. Then your lordships will see, my lord, clause 7, which is in the same page. My lord, this provides for termination. Now, my lord, this is a very important provision. My lord, this ultimately provides that the agreement will not be determinable and will not be determined. The government shall not terminate this agreement under any circumstances before the expiration of the tenure of this agreement, subject to any non-compliance or any breach under this agreement or MOU as mentioned under clause 8 of the MOU by the private partner. In such cases, the Department of Health and Family Welfare shall provide a 45 days notice to the private partner for removing the said non-compliance, and in the event of not remedying the non-compliance within this time frame, the Department of Health and Family Welfare can terminate this agreement by providing 90 days notice. Well, what this clause says is, first, it is not terminable at all. Second, my lord, it may be terminated in the event of a breach. But in the event of a breach, you must first give them a cure period notice of 45 days to cure or remedy the alleged breach. And if that is not cured within 90 days, then you will give them a further notice of 90 days before terminating. That is the purport of the agreement. Now, my lord, one more clause I'd like to show you, lordships. Well, that is clause 14.3, which is at page 39. Well, 14.3 provides for specific performance in express terms. At page 39. It says, this MOU shall be specifically enforceable at the instance of any party. The parties agree that a non-defaulting party will suffer immediate material, immeasurable, continuing and irreparable damage and harm in the event of any breach of this MOU, and the remedies as applicable law in respect of such breach will be inadequate, and that such non-defaulting party shall be entitled to seek specific performance against the defaulting party for performance of its obligation under this MOU, in addition to any and all other legal or equitable remedies. Now, well, there was no difficulty in the operation of this agreement till July 2024.
No, but then how has this cost title been framed? Suraksha Salvia.
It is, if your lordship now sees, if you please see, the MOU once again. But it is an inadvertent error which has never been given effect to. Because after this MOU was entered into in 2019, all licenses were issued to the petitioner. All permissions to operate were issued to the petitioner. All filings were in the name of the petitioner. All invoices were raised by the petitioner.
Therefore, correctly, it should have been Suraksha Specialty LLP and Salvia Global LLP.
No, the name is Suraksha Salvia LLP. That is the name of the new LLP, which is the coming together of the Suraksha entity and the Salvia Global entity. It is inadvertent. But ultimately, this was really corrected by the parties by their conduct. They acquiesced to this position. Because all permissions to operate were granted to the petitioner LLP.
After amalgamation, what is the name?
Suraksha Salvia LLP, the petitioner.
Not Global.
No. Global is one of the entities. One entity is Salvia Global. The other entity is Suraksha. And both of them have signed the MOU independently. The constituent name is Suraksha Salvia LLP. Now, this was never given any importance because the parties accepted that this is inadvertent, this is an error, and they proceeded to accept the petitioner Suraksha Salvia LLP as the constituent partner under this MOU. Why? Because first I have to obtain from the state itself consent and permission to operate. I have to obtain requisite licenses. All the licenses were issued in the name of the petitioner.
Then, Mr. Shah, you have to file a supplementary affidavit that bringing on record the correct cost title, or explain.
What we have done is, we have always pursued the matter in the name of the petitioner, saying that this was an inadvertent error which the parties had ultimately rectified by their conduct. That is our statement in the case. That is our case.
But there is no organization by the name of Suraksha Salvia Global.
No, that is what we have mentioned also in the petition.
Then a petition cannot proceed. Cannot be proceeded by a non-entity.
No, the petition has not been filed by the non-entity. The petition has been filed by the entity which is registered with ROC. The petition has been filed by Salvia, Suraksha Salvia LLP. That is a registered LLP.
The appeal, there is a mistake in the appeal.
No, the appeal has also been filed by Suraksha Salvia LLP.
Global LLP.
Appeal has been filed by Suraksha Salvia LLP. The MOU is in the name of Suraksha Salvia Global. Appeal is filed by Suraksha Salvia LLP.
No,
Section 9 by Suraksha Salvia LLP.
But in the court of the commercial court, Shillong?
That is also Suraksha Salvia LLP.
You have a look.
Page 182 of the paperbook. 182.
It is Suraksha Salvia LLP, page 182 of the paperbook. That is also filed by Suraksha Salvia LLP.
182.
Mention global.
That's on
No, those court papers.
this is an order sheet. No, this is an order sheet. This is not 182. What is it? 182. Go to 182.
273.
182.
Those court papers.
No, this is not paper. No. This is not a document. What is it? Correct. Salvia LLP to the reported information.
Section 9 petition to report.
I know.
Section 9 application. This is our application.
Section 9 application.
Okay, so this will be at page, this is appeal, this will be at page. Please come to page 246. 246. This will be at appeal. 206.
Well, the petition is, well, I don't know whether there's a mistake in the order sheet. The petition is, well, filed in the name of the
246.
well, this is the petition under section 9. It is filed in the correct name.
Yes.
Well, there is apparently some mistake, my lord, in the order sheet. Now, my lord, so far as the petition is,
What is the issue involved? What is the controversy?
I'll tell you, lordship. My lord, the MOU, my lord, said that you shall, my lord, function for 10 years. It will not be terminated. You can specifically enforce the agreement. My lord, so far as they are concerned, there was no difficulty, my lord, till July 2024.
What was the date of the MOU?
My lord, the date is 21st June 2019.
Yes.
Now, my lord, everything was fine. My lord, invoices were being raised in the name of, my lord, Suraksha Salve LLP. Invoices being paid to Suraksha Salve LLP. Permission to operate, licenses all granted to Suraksha Salve LLP. No difficulty. My lord, then, my lord, without, my lord, taking your lordship through the papers. Then, my lord, suddenly a meeting is held, my lord, in July 2024, where, my lord, we are appreciated, our role is appreciated, but then they say we want to set up a medical college, so please agree to the termination of the, my lord, MOU. My lord, we want some time to deliberate on the matter. My lord, we say that we cannot agree because the financial implications will be immense. My lord, because the entire idea of, my lord, locking in the agreement for a 10-year period was to protect, my lord, our investment and our, my lord, remuneration or return on investment. My lord, when we don't agree to do that, they serve a notice, show cause notice.
When was this request made to vacate?
My lord, this was on 29th July 2024.
150 of the paper book.
My lord, please see page 150 of the paper book. It is there. Now, Lord, very interestingly, here your lordship will see, my lord, this is the minutes of a meeting held on 29 July 2024 at, my lord, page 150. My lord, please see serial number 8 of the persons present, members present. Suraksha officials, such and such, director of Suraksha Salve LLP. My lord, this is the petitioner entity. So, my lord, they are invited to the meeting, and then, my lord, first paragraph, please see. The Commissioner and Secretary of the Government of Meghalaya, such and such, warmly welcomed all participants and led an in-depth discussion on the role of Suraksha Diagnostics within the Health and Family Welfare Department of Meghalaya, including its impact and contributions to the citizens of Meghalaya to date. He informed that this meeting has been convened subsequent to a previous meeting by the Principal Secretary on 10 July 2024 on the operation of the state-of-art diagnostics, where Learned Advocate General was also present. Then, my lord, the key points here, my lord, kindly see. It was conveyed, my lord, this is, my lord, the first time it is, my lord, brought up, conveyed to the representative of the Suraksha, due to the priorities of the state government. The minutes of meeting has to be revisited. The government has decided to establish Shillong Medical College in the Pasteur Institute and will require all the existing infrastructure, including the big building occupied by Suraksha Diagnostics. In view of the requirement for establishing the Shillong Medical College, it was considered proper to invite representatives of Suraksha for an amicable termination of the MOU that was executed. Well, this is where the dispute started. Now, my lord, we naturally, my lord, said that no, we do not agree to this termination, my lord, which led to, my lord, issuance of a show cause notice. My lord, please see, my lord, page 166 of the paper book. This is the show cause notice. Very interestingly, at page 166, your lordships will find, my lord, this show cause notice is issued to whom? To Suraksha Salve LLP. That is the petitioner entity. Not to Suraksha Salvia Global. And my lord, here, what is stated, well, if your lordships will see the second paragraph, and whereas for the realization of the objectives of the Health and Family Welfare Department, entered into a memorandum of understanding on 21st June 2019. Now, here they mention the word Suraksha Salvia Global LLP, but they serve the notice on Suraksha Salvia LLP, outlining the specific responsibilities of Suraksha Salvia Global LLP. Then, my lord, they say that you are a private partner, and then please see, my lord, towards the bottom of the page, they say that Suraksha Salvia LLP Medical and Diagnostic Laboratories. Now, my lord, please see again. What? Suraksha Salvia LLP. Who has failed to meet the objectives? Suraksha Salvia LLP.
166.
My lord, notice issued to my lord Suraksha Salvia LLP. Show cause notice. And the ground for termination, last paragraph. Whereas Suraksha Salvia LLP Medical and Diagnostic Laboratories has failed to meet the terms and conditions. Now, this is for the first time this allegation is made. In fact, your lordship has seen in the previous, my lord, minutes of meeting at 29 July, they, my lord, applauded our activities. Now, my lord, the requirement of the contract, as your lordships have seen, is that even if, assuming that there was in fact, my lord, a breach in the performance of obligations, there was a requirement to give a 45-day cure period notice. No mention of that. Well, it simply says that in view of the foregoing, you are hereby directed to show cause within 15 days from the date of receipt of this notice as to why the MOU should not be terminated for breach of terms. Now, my lord, we respond to this show cause notice. There's obviously, my lord, no heed paid to the response. And then, my lord, the termination follows. My lord, that your lordship will find termination is effected on the 30th of January 2025
172.
at page 172. Well, it's really at 173.
Were you to pay them any fee or charges or rent?
Nothing. There is no default in payment of any money, no default in rendering.
Were you required to pay any rent or?
Nothing. I was required to invest in, my lord, equipment. I was required to invest in, my lord, specialized, my lord, technicians. I was required to, my lord, invest in, my lord, some infrastructure. And, my lord, I was supposed to render services and raise my bills, which I have been doing, my lord, without any blemish. No prior, my lord, allegation of any breach on my part in rendering the services which I was supposed to render.
Bills means bills for doing
Diagnostic services, for rendering diagnostic services.
to government employees.
Yes, to government. No, to my lord, I was raising my bills on the government. I was raising my bills on the government was paying my bills.
So that means it must have been for their employees.
Yes. My employees or, my lord, whoever the government, my lord, for the government hospitals. Now, my lord, at this juncture, my lord, then they, my lord, serve as the notice of termination. My lord, notice of termination again bad because A, the agreement is, my lord, non-determinable. B, my lord, even if there is a breach, of course, if there is no prior history of any breach, then you must give me a 45-day cure period. And then thereafter, if there is no curing of the breach,
When
you must
was
give me 90 days.
termination? Termination on?
My lord, termination, my lord, was 30th January 2025. Page 173. Now, my lord, as soon as they serve on this notice on termination, they want to take over, my lord, possession of the facility. So, my lord, I am constrained to, my lord, approach the commercial court with a petition under section 9, after, of course, serving on them a notice under section 21 of the Arbitration and Conciliation Act. Now, my lord, when the section 9 petition is filed, my lord, the prayers in the section 9 petition are, my lord, for an order of injunction restraining them, my lord, from giving any effect to the termination notice or from, my lord, taking over possession of the facility. My lord, the matter is, my lord, heard on contested hearing. And on 12th February 2025, at page 227, your lordship will find an order, my lord, this is an ad interim order passed in the section 9 matter, where, my lord, the learned commercial court ultimately, my lord, discusses the merits of the matter, reviews, my lord, the provisions of the agreement, and, my lord, ultimately, my lord, directs at page 242. Well, this is the operative portion of the order. Will you kindly see the portion in bold? Therefore, this court hereby grants interim ad interim injunction till the next date, restraining the respondents from giving effect to the notice of termination dated 30th January 2025, and a restraint from disturbing the possession of the petitioner at the subject diagnostic center at Pastor Hill, Shillong, Meghalaya, in terms of the notice of termination dated 30th January 2025. Well, this is the ad interim order that is, well, made. Then, my lord, on the returnable date, the matter, my lord, is again taken up for hearing. On that date, my lord, on the 19th of March, my lord, an undertaking is given.
Returnable dates are undertaking issue 19th March or position 19th March repossession order of March.
Well, lord, on the 19th, my lord, the matter was being heard by court, and in the course of hearing, well, an assurance had been given to my lord court that no coercive order would be made. Now, my lord, notwithstanding such fact, on the 19th of March 2025, my lord, forcibly, my lord, possession is taken over. In these circumstances, my lord, we file immediately on the 19th of March itself, we file an application for, my lord, restoration of possession. 257. My lord, that petition is also a part of the records. But, my lord, without troubling your lordship with that, my lord, kindly see an order that the court passed on 19th of March 2025 at page 266. My lord, what is very important, my lord, is, my lord, your lordship will kindly have a look at page 269, the last paragraph, at page 269. Just the last paragraph, if your lordships will see. This court was under the impression that the opposite party would not take any coercive steps till the matter is decided. However, the action of the opposite party in forcibly dispossessing the petitioner without following the due process of law is uncalled for, especially from the government. Taking a cue from the aforesaid judgment, this court cannot turn a blind eye to the unlawful conduct to dispossess the petitioner from the demised property. If the court gives acceptance to such high-handed action, there will be no respect for the rule of law, and unlawful elements would take hold of the due process of law for ransom, and it would be a field day for anarchy. Due process of law would be put to ridicule in the estimate of the law-abiding citizen, and rule of law would remain a mortuary. Hence,
what is the order against which this appeal has been passed?
Now, my lord, the order of repossession is made. My lord, before the repossession is filed, my lord, what my learned friends do is, my lord, against this order directing repossession, they come up and file an application before this court under Article 227. The court says that very well, we shall hear the matter, but since the court has been approached to decide the question of maintainability in view of, my lord, the fact that the name in the, my lord, MOU is Salvia Global LLP, let that be decided. Now, my lord, when the matter goes back to the learned commercial court, the learned commercial court, my lord, hears the matter in depth in arguments on questions of law, but then says that no, it is Salvia Global LLP. That is not a party to the petition, so I am dismissing the petition. Well, that is all. Now, my lord, so far as that is concerned, first of all,
what is the interim order we have passed?
Your lordships have, my lord, asked status quo to be maintained in respect of all 4 blocks. In respect of Block A in its entirety.
Mr. Advocate General.
Yes, my lord.
let the court below hear out the section 9 because going into factual
No,
matters
section 9 has been disposed of, dismissed.
Section 9 has
on a technical ground.
No, my lord, the on
Not
the
on
merit,
merits.
on merit, it has been decided that
I shall show you, Lordship, the impugned order. Only one
part
paragraph.
has not been shown. The correct, what my friend will show now, the issue is, my lord, Salvia Global LLP is one entity. Kindly notice Salvia.
Not in legal existence at all.
It is in legal. I have got the LLP document and it is in existence and it is signed also from a MOU. Everything is there.
My lord.
On 21st June 2020, my lord, Salvia Global entered into an agreement with the government. Kindly, Salvia Global. Because
My lord, may I address your Lordship? My
Salvia
lord, may I then
Global, I will
finish the
show
matter?
from that only.
My lord, may I-
And the petition is being filed by a party which is not party to the MOU. Now I'll show you, my
Three
lordship,
legal arguments
two,
to that.
two
No,
pages,
my lord,
my lord.
let me, my lord, finish. I shall show you, Lordship, my lord, without, my lord, a shred of doubt, my lord, that, my lord, they have dealt with Salvia, my lord, Suraksha Salvia LLP throughout. Now, my lord, because they want to, my lord, terminate, they are, my lord, taking this as a technical plea.
This is not.
Now, my lord, so far as this is concerned, three legal arguments. One, my lord, clearly an inadvertent error which the parties have themselves rectified by their own conduct. Because they have accepted me, my lord, they have performed with me, they have accepted my performance, they have, my lord, accepted my invoices, they have made payments to me. They have allowed me to be licensed with the government authorities for running this, my lord, diagnostic center. That is, my lord, the first, my lord, answer. The second answer is, my lord, here, my lord, today, my lord, this, my lord, even if, my lord, today the agreement was with Salvia Global LLP, it has been novated sub silentio by conduct of the parties.
No, but it cannot be. Under the Evidence Act, a written agreement can only be changed by a written document.
No, my lord, I think, my lord, with the greatest of respect, my lord, I can, my lord, show your lordship the authority. But, my lord, be that as it may, here, my lord, they have accepted.
Unless a subsequent event can be. Orally you modify that agreement. But that self-same written agreement you cannot modify by an oral.
No, my lord, they have accepted the performance through a different entity. Now, my lord, the third parties. Now, my lord, the law is so well settled, my lord, after Cox and Kings, my lord, which has been followed by OP Global Energy, my lord, 2004, 2024, 2025. The Supreme Court has made it clear that even a non-signatory, non-party, my lord, when it can be a party to an arbitration agreement, it pursue its remedies under the arbitration agreement. It says when you are integrally connected with the contract in question, when you are integrally associated with the performance of the contract in question, it makes no difference as to whether you are named party or not. You will still be deemed to a party, you will still be able to
Is
participate.
there a named arbitrator?
No. A named arbitrator.
We have given a section 821 notice.
No, there is no named arbitrator. We have suggested.
No, but what does the arbitration clause say? That by
I'll just tell you, Lordship. My lord, the arbitration clause says, my lord, place of arbitration shall be Meghalaya, and then says sole arbitrator. No named arbitrator, sole arbitrator.
by consent of the parties.
Sole arbitrator
By
by consent.
agreement.
My lord,
You agree on an arbitrator, let him decide this question.
only 5 minutes, my lord. Why? Because there is no right vested in the appellant before your lordship to invoke arbitration clause.
No, if
I have
if
to argue that matter
If,
on law.
if anything is not there, he cites a Supreme Court decision
The issue
which
will not
says
be-
that one who has a stake or interest in a.
No, will not be, what is the case before of the appellant before your lordship? Case is that I am signatory to the MOU of 21st January 2020, 21st June 2020, my lord. Now, the second argument, which destroys the first argument, though I may not be party, but I am intricately connected to the MOU.
It's an argument in the alternative. It's not, my lord.
The argument
an
which is
inconsistent
destroying the first, and kindly see the MOU for a moment. My lord, 2 documents in 5 minutes matter will be
Well,
over.
I
And
have to
third
argue this
objection,
matter
my
on
lord,
law.
This appeal is not maintainable for the reason that it has been filed against the interim order. Against the main order, there is no appeal. The commercial case number 2, which was disposed of in the light of the decision, that there is no challenge to that order before your lordship. Kindly see the prayer. How the
Well,
interim-
there is one order which has dismissed, my lord, my petition.
and that order, if your lordship
That
will
is
kindly
order
see the
challenge.
prayer, kindly see the prayer. Prayer is only against the miscellaneous order. There is no challenge to the main petition. And section 8 of the Commercial Court Act bars the challenge. But I will go to that route later on, my lord. First, I have to show that this entity is not party to the MOU, and it is there throughout their case that this is a third entity that was doing it, my lord. I will show it from that.
This will take time. Then, if you argue the appeal, we will post it in June, Mr. Shah. subject to your convenience after.
Kindly do so, my lord, because this matter will have to be heard. There, my lord, what my learned friend is saying, my lord, this is, my lord, a flexing of muscle.
This
He
is not
says
a
now I
flex-
shall,
this
my
is
lord,
not
after
flexing of
allowing the performance of the
Your
LLP,
lordship that I have spent 20
kindly,
crore rupees.
kindly
What
ask
the
my
kind
learned
of-
friend
the-
who
this
has,
is
my lord,
in-
run the diagnostic center for so long,
They
who has
have,
dealt
I
bills,
also
and
from
whose
the
bills have been
total
paid.
employees, they are posted only 20
Well,
and their total expenses.
Mr.
I also-
Advocate General, I have understood. Number one, that on record he is not a party to the arbitration
Yes,
agreement. Now he says by conduct, by performance, you have accepted performance. Now the question is whether a written arbitration agreement can be modified or altered by conduct or by any oral arrangement. That particular agreement, not any subsequent agreement which may be entered into
There is
by
no
the party.
agreement, my lord.
All
And
right.
conduct also is in my favor. I will show
Third,
that.
all are alternatives that according to our Supreme Court decision,
Yes, my lord.
that even if somebody is not a party, if one has a sufficient interest or stake in the subject matter of arbitration,
Yes.
he can be a party to the arbitration. He may not be a party to the arbitration agreement, but can invoke the arbitration clause and seek resolution of the dispute under that
Yes, my lord.
mechanism.
But the core issue before your lordship is that it is a Section 9 application for interim order, my lord. Section 9 application. A scope of Section 9 for interim injunction in a determinable contract, the compensation is
Is
the
it a
only remedy.
determinable
That is also
contract?
the issue. which
When
your
the
lordship will have to
contract says it
look
will be
into.
specifically
Right.
enforceable, how can my learned friend say it's a determinable contract?
Section 9 application, everything comes in, but all tentatively.
Yes, your lordship, but in determinable contract, my lord,
It is
the
not a
limit-
determinable
Now, the question is, your lordship will have to address, in determinable contract, can they ask for a specific performance? Their case would be at best for compensation.
Is it a determinable
It is-
contract?
Now the question is, that issue will also lie before your lordship.
Yes, my lord,
It is-
kindly decide that.
That is the scope of Section 9, my lord.
Kindly
In the
decide that
determin-
question.
So first question is, my lord, your lordship has rightly framed and correctly put to us that whether the party before your lordship is party to the MOU or not.
I don't know whether they have taken the point or will take the point.
Yes, my lord.
I'm just
Yes, lordship.
I'm just observing from my little knowledge that I have
Lord.
that if an agency or a license
Yes, ma'am.
is coupled with an interest, then it is not very easily determinable.
Section 202, my lord,
There,
the lordships
my lord,
have held
my
of
lord,
the Contract
the
Act.
series of judgment, even Cox and King of 2012, my lord. Cox and King of Justice Altamus Kabir Supreme Court judgment, my lord. It says under 14, because 14(1)(b) of Specific Relief Acts requires the specific relief will not be granted where day-to-day monitoring is required. 14(1)(d) says if determinable contract.
Why did my learned
And
friend
then
say
40,
it will be
20A,
specific and
my lord,
enforceable, it will not be
20A, my lord,
determinable?
all these issues. So therefore, now the question which falls for your lordship's kind consideration is whether my case is that he is not party to the MOU, so therefore he has no right to invoke Section 9. That is one. Second, his own conduct, I will show that throughout Salvia Global LLP is the party to the agreement, and it has been doing.
No, this licensor-licensee agreement
Yes,
with
ma'am.
terms and conditions
Yes, ma'am.
can well form subject matter of an arbitration agreement.
It will only in respect.
It is not a rent-act tenancy.
Yeah, it's not
Covered by
a
the
sovereign.
rent act.
It's not a sovereign subject where I am saying that.
So all these issues regarding termination, possession, eviction, all will be within the.
It is within the realm of the arbitrator, but the only relief which the party will be entitled to in case of the finding is returned that it is illegal termination, compensation only, my lord. That is also settled law, my lord. I have got the judgments with authorities today also. I will place.
I also have the authorities, including an authority, my lord, which answers your lordship's query, which says that, my lord, by conduct of parties, the written agreement
So
can
now the
also be, my
question,
lord, novated sub silentio.
they are shifting the stand, my lord.
It can be, but subsequently.
Yes, of course, subsequently.
Our lordship, even their own lawyer has given the notice saying that my name is Salvia Global LLP and the notice so called is this, correct the name. I will show the document. And their own expenses, they show that expenses has been incurred by Suraksha Specialty Limited.
Well, lord,
which is one of
may I
the
make a suggestion?
Whenever it is convenient for you, after this.
May I make a
only
suggestion?
one submission I was having.
Lord, may I make a suggestion?
I have not issue on date.
My lord, may I make a suggestion? Well, ultimately, my lord, my lord, we have to, my lord, go to arbitration. So, my lord, if my learned friend agrees to a name, my lord, arbitrator, or
That
if
is
your
what I
lordship
said.
says, we shall, my lord, immediately, my lord,
amount to
it will have
conceding to the position where a party who is not
my
party
lord,
to the arbitration.
no, my lord, what
agreement.
has happened, the law in this regard is also clear.
Law is also settled.
Well,
law is also in my favor.
Well, may I just
but,
suggest this? The arbitrator can decide the question, including the question.
That is what I said.
Yes.
Milord, because it's a Section 9 application where no interim relief could be granted and he is not party to the agreement. I am ready to argue any day on this.
I am
issue.
also ready to argue. But, my
And-
lord, I can also suggest that, my lord, since your lordships has said that lordships will, my lord, be taking it up later. My lord, if my learned friends, my lord, want to, my lord, sit and, my lord, amicably resolve the matter, we can try to do that.
Milord,
But, my lord, there has to be
in July of 2024, we asked for amicable resolution of the matter. Your Lordship has seen the letter.
Because, Mr. Advocate General, if an agreement is manifestly on the face of it,
Yes, my lord.
appears to be invalid, void,
Yes, my lord.
then an arbitrator assumes no jurisdiction under that contract.
Yes, ma'am.
Even prima facie, the court can hold
Yes,
that.
ma'am. Yes, ma'am.
But here it is a contentious issue that whether he is a beneficiary of the arbitration agreement. Now, in that case, under Section 16, the arbitrator can.
Your Lordship is right, my lord, that so far as that aspect is concerned, under Section 11, he moves and then possibly that issue can arise.
You do one thing.
Yes, my lord.
We will keep it second week of June. Mr. Shah, are you available second week of June?
Yes, ma'am. Well, after the 9th of June, my lord, anytime, my lord,
Yes.
in the week following.
You do one thing. You try at settlement. That all learned lawyers can.
Yes, my lord, we are ready.
And second, if that procedure does not work, try to agree on a learned arbitrator.
No, my lord, before that, because kindly, I need only 5 minutes to show that the arbitration cannot be invoked by the appellant.
My lord, the matter will have
Only
to be
5
heard.
minutes.
My lord,
My friend has argued
a
for
piecemeal-
45 minutes.
No, my lord, it
And
can't be
the
done.
fact has not been disclosed on 21st.
That means that you will not submit to arbitration. That is it.
Yes, my lord. With the appellant, I will
Then
not.
settlement, there is no problem.
The settlement is possible with the Salvia Global LLP has approached us for settlement. Salvia Global LLP is not before the party to the agreement. Christopher Rani has
There
been
is no
there
Salvia
all the
Global
time.
LLP.
He's a partner. He's a partner.
And Salvia Global
Salvia
is the real
Global-
entity and they are open to the argument. They are blocking it, my lord. That is and we are ready to settle because we have spent, it's not their equipment, it is my equipment which we have got 20 crore rupees. What they show in the expenditure of 4 crore rupees, my lord, 1 crore 80 lakh rupees on headquarter in Calcutta.
So we will say that either you will bring Salvia Global or at the settlement table show that
No,
you
my lord,
have-
Salvia Global is my, my lord, LLP partner. My lord, I am Suraksha Salvia LLP. My lord, we are together Suraksha Salvia LLP. Salvia Global LLP is, my lord, one of the partners of Suraksha Salvia LLP. My lord, they can't, my lord,
Very
independently go and, my lord,
convoluted arrangement, my lord. I will show how this arrangement.
No, my lord,
happens.
it's
very convoluted.
my lord, today your lordships have
no.
held.
Can they take part in the settlement process or not?
No.
They
cannot independently do so.
They are
My lord, that will
MOU
be barred.
partner.
With you,
Of course, with me they can.
both of you.
My lord, Suraksha Salvia LLP and my lord, Suraksha, my lord, they can all together sit.
Yes, then there is no problem.
I have no issue, my lord. Any day they can sit. Tomorrow also we can invite them and then we can settle
So-
their matter.
So we,
But
we, we will-
they are blocking my medical college. They are arm twisting my medical college. I'm
there
only
is a contract.
and we have spent the
It
money
is a
on the
determined-
medical
not a
college, my
determinable
lord.
contract.
Because my
I have some
college
rights
is going
which
to
are
be
accrued.
inspected in June, my lord, and they are saying and ultimately if I succeed also I will have irreparable loss, my lord. BCD block, they are blocking BCD block. A block.
My lord, I have, my lord,
and they are not
made out the
permitting us-
prima facie case before the learned, my lord,
and
commercial
the
court.
district judge has rendered the finding, my lord, that
The finding has not been rendered on the merits at all. There's one line finding that since it's Suraksha Global LLP.
Page finding, my lord, where everything
right.
has been contained.
list is submitted for further consideration on 11 June
May
2025.
have it after 20th, 23rd is if you're convenient. 23rd probably.
June.
23rd June.
All
Well,
right.
if your lordship will then hear out the appeal. In the meantime, we'll of course try to, my lord, see if a settlement can be reached. Then, my lord, may I request your lordship for 30th of June?
All right.
Then I can come physically.
And I was praying, my lord, because A is already under the lock and key and we are not. B, C, D, my lord, because ultimately if we succeed also, my lord, And I'm pretty sure that.
Because in the absence of change of circumstances, we cannot
So,
change
Your
the
Lordship,
interim order. The
fact-
interim order will continue.
So interim order, we will not alter
Your
the
Lordship has
character,
permitted
nature,
them to, my lord,
anything.
convert it into
BCD,
classrooms
my lord, block.
subject to the results
even
of the
Christopher
application.
Rani, who is the partner, he says that I was in A, my lord. BCD, your lordship.
Well,
permit,
this is what your lordships have
subject
said.
to outcome.
Well, this is
Subject
your
to
lordship's
outcome.
order.
Remember, temporary structure they can make.
Well, this is what your lordship's order is. It's already there. Well, petitioner said between his clients such and such, but the blocks BCD were also allocated. Then, my lord, your lordships have held. Well, this is your lordship's last order. In those circumstances, we direct the special officer already appointed to take symbolic possession of blocks A, B, C, and D. We restrain the parties from creating third-party rights in respect of those areas. Respondent state may proceed with the creation of classrooms in blocks B, C, and D, but any construction shall be strictly temporary and removable in the event the petitioner succeeds.
Only thing, my
Status
lord,
quo,
if
my
in
lord.
block D, my lord, we are creating one extra structure over D. That will not hamper them. That will not cause.
Mr. Advocate General, unnecessarily don't pressurize the court because the government, how they move, we know.
No, my lord, we will not. If your lordship rules in their favor, my lord, we will demolish it.
Expansion of one airport, they are taking year after year. And they want to build
It has taken 10 years, my lord, to reach to this level in medical college.
And the
my lord.
classroom, they want to finish off in 15 days.
No, my lord, it has taken 10 years. In medical college, we have 10 years, my lord. Only thing which I was saying that permit us to do the temporary.
Well, kindly do not, my lord. Your lordship has already granted them
Yes,
certain
so.
liberties.
BCD, we should be
My
permitted
lord,
to
let my
have the
lordship, my
classes.
lord, not pressurize the court like this.
Pressurizing.
No, my lord, this is, my lord.
All right, list the appeal for further hearing on 30th June. All interim orders in the appeal shall continue till disposal of the appeal or until further orders. Paragraph in the meantime. Suraksha Salvia LLP together with
Salvia Global LLP, my lord.
Salvia Global LLP and
And
the state of Meghalaya,
ठीक है, together with body check.
comma, through their respective learned counsel shall sit to the learned counsel shall sit together to work out a settlement if possible. By 10 June 2025.
Grateful.
yes.
The result shall be made known to the court. This proposal of the court to sit for settlement is at the suggestion of learned counsel.
Well, only one more request, my lord. Your lordship has on the 14th of May disposed of all the other applications because they had become infructuous in view of the interim orders already passed. There was one application under Order 41, Rule 27, which has also, my lord, been.
No, it is pending. Order 41, Rule 27 is pending.
that-
7 or something, I remember.
Well,
And
that
kindly
is.
permit us to file because we have not filed reply to the application also. We will file in the meantime reply to the because only petition have they filed and they have made certain additional averment which was not before the learned district court also, my lord. So we need to file reply, my lord.
Well, let my lordship write reply. I don't have any
And
objection.
some certain documents which were there, including my argument.
Well, kindly, my lord, make it clear that the Order 41, Rule 27 application, my lord, will receive your lordship's consideration along with the main appeal. Well, that is the order that your lordships usually pass. Well, because the order, my lord, records that MCFA 4 of 2025 is also, my lord, disposed of. That is your lordship's order 14th May. We have filed a my lord, application for recalling a formal application.
What is the number of that application?
Well, MCFA 4 of 2025. Contempt Matter along with appeal and MCFA4 is treated with release, also disposed of. I'm sorry. Disposing of 3 and 4. Well, at the first line. Well, at the 4, my lord, will have to.
We are directing listing of the appeal along with the contempt matter 19th May.
Disposing of MCFA3 and MCFA4. MCFA4, my lord, also goes, my lord, by this observation.
This is MC4. Right.
No, the order dated 14/5/2025 is corrected. By stating that MC bracket FA number 4 of 2025 is not disposed of and is pending. Then in the end, this appeal (3 of 25, 7 of 25, 4 of 25), along with the contempt case. So only MC3 is disposed of.
Yes, ma'am.
And 5. Okay.
Grateful.
In the meantime, we will file reply to the application.
Number, you all should check up.
In the meantime, we will file reply to the application, sir.
Yes. All affidavits may be completed in the meantime.
Yes, grateful.
Grateful.
Huh?
बोले दीजिए चलो.
All right. Miscellaneous case, this is there in the list today? All right. Miss case 9 of 2025 is treated as on the day's list. Then the order they said so and so is corrected by so and so.
Grateful.
9 is disposed. When has he filed it? When has he filed? Somebody has to introduce the report. The report of the special officer? Is taken on record. Copies thereof may be circulated to the parties, if not circulated earlier.
Yes, take.
Yes.
Grateful.
I remember. See, the problem with you is Mr. Datta's matter was parted yesterday. You put this matter before it, which was not parted. And ensured that his matter is not heard today, and this matter gets precedence. The matter which was going on should have been first. Don't smile. You will sit here up to, as your Mary has said. Yes, Mr. This is not appreciated. Day after day you are doing this. Yes.
Well, the other day I was.
All other matters will be posted tomorrow. Mr. Datta will continue.
Your Lordship, I'm praying item 19 to appear.
Please don't mention, come tomorrow and do the matter. It is not a kind of a mandate that all matters have to be taken up from the list.
No, Your Lordship, I'm just praying for Thursday, Your Lordship.
What?
I'm praying only to be listed on Thursday, Your Lordship.
Item number?
19, Your Lordship.
Who's on the other side? All right.
There's no urgency.
By consent of learned counsel for the parties, list this application on Thursday.
Obliged, Your Lordship.
So that you can go home, taxing the court. You better will come tomorrow at the time of first call said that I'm mentioning this matter for Thursday. You try to understand this. You are making your work lighter that I will mention the matter and hop, skip and jump.
No, Your Lordship.
Yes, Mr. Datta.
Well,
Don't do all these things.
Well, I was referring to the order the work order by which the work was allotted. That Your Lordship will find at page 121. I am referring to Writ Appeal 36 of 2024.
Yes.
Page 121, Your Lordship will find the work order which was challenged before the Honorable Single Judge. The work order makes it very clear that pursuant to the work order, issuance of the work order, certain post-tender conditions are to be complied with. Now, if Your Lordship will kindly read the second paragraph, the work should be started immediately in consultation with so-and-so, and it should be completed in all respect within 18 months from the date of issue of this work order. Third paragraph is very important, Lordship. Please attend the office of the undersigned. Please attend the office of the undersigned in any working days during office hours for signing the tender agreements in so-and-so form before starting the work. So there was an agreement which was to be signed, and as the materials on record would show, there is no agreement executed between the parties. At least the MEPGCL have also not said so. The contractor who had got the tender, he has also not said that any agreement was executed between them. Now, if Your Lordship will kindly see the condition, page 94 clauses 15 and 18 very clearly indicate that there are certain post-tender conditions which have to be satisfied before the work is commenced. If Your Lordship will kindly come to page 94.
No, that unsuccessful tenderer cannot probe into.
No, I'm not
the
on
way of performance of the contract.
No, I am not on that
So
point.
you
Lordship.
should be you should be confined to your interest only in the contract.
No, my endeavor, why I am showing this to Your Lordship, my Lord, is to demonstrate that as to what was the time from which they started working, because they have raised a claim. They had worked for 3 months and made 25% of work and etc. My endeavor is only to show Your Lordship that the fact otherwise demonstrates.
No, but what has the learned judge recorded?
My Lord, there was no deliberation on that point. These things were that, my Lord, 6th of March, if Your Lordship will kindly note the date, 6th of March we came before the Honorable Court saying that the work has commenced, because there were certain post-tender conditions which were to be observed, and therefore naturally they could not begin the work before February. 6th of March we told the Honorable Court that the work commenced. Honorable Court asked an affidavit to be filed. We filed the affidavit on 8th of March. 24. 6th of March we informed the court. Honorable Court recorded that in the order and directed us to file an affidavit. We filed it on 8th of March. The matter stood for consideration of the Honorable Court, and finally on 10th of April, my Lord, it transpired. The 10th of April, the Honorable Court examined the records of the case, and it transpired that thereafter the work had stopped. And if your lordship will kindly see the order passed by your lordships on this writ appeal, on this writ appeal, my lord, your lordship had posed a question to the counsel for the MEPGCL on 25th of October 2024 as to the status of the order. And in pursuance thereof, my lord, he had informed your lordship that the work has stopped for almost 6 months. That your lordship's order of 25th of October is showing that, my lord, that they are status.
Mr. Datta, we cannot go into this issue. It's a dispute. Then we have to put up witnesses here. Take evidence.
No, my lord,
Send a special officer or commissioner.
My lord,
to the site.
my limited endeavor is to only demonstrate before your lordship.
That no prejudice has been suffered by them. That is all.
Yes, exactly. Now, if your lordship, as I have shown to your lordship on the other day from the additional affidavit, the additional
No, but
affidavit.
this is very important. Who's appealing for Mr. Pandey is there?
My lord, yes.
Yes, Pandey.
Yes, my lords.
The state should file an affidavit as to how much work has been completed by them before 10th April and how much you have paid them. Have you paid any RA bill?
My learned friend said that she has not received any.
Huh?
My learned friend for the respondent said that she did not receive, she did not raise any bill. No bill has been raised. The other day she told like that. Your lordship's query was that what was the, amount of bill or anything.
Mr. Pandey, will you be able to take instructions? Oral, let not I don't want affidavit. Your statement will do. That that how much work has been completed.
I will take instructions, my lord. I will take instructions, my lords, on these issues as far as the status of the work is concerned and the amount of money which has been paid.
No, but get it by tomorrow. Mr. Datta, you are coming from Guwahati.
Yes, my lord. But tomorrow and day after, I am very badly tied up at Guwahati, my lord. If your lordship gives some date, 27th or 28th of this month.
No, then after 10th June.
After 10th June.
Yes.
Lordship can give us 19th of June.
No, that is too far.
Or 12th of June.
12th of June.
12th of June.
Yes.
Lordship, may I pray, Lordship, 15th of June? Oh, sorry, Lordship, let me go. Let's see.
15th of June is Sunday.
Lordship, 16th of June, Lordship, I'm sorry.
No. Why we have opened online arguments for
Lordship,
this?
Lordship. Yes,
Then why this
no, I thought it's a
juggling of dates? Mr.
Lordship,
Datta, 12th is all right with you?
Yes.
Lordship.
List this appeal for further consideration on 12th June. Mr. Pandey, learned advocate for the state, shall obtain instructions as to the quantity of work done by Ms. Parveen's client, Ms. Parveen, learned advocate's client. Give his name. Respondent number so and so.
Taibin Varzari.
And the amount of payment and to what extent payment has been made to him.
But he said that he has not raised any bill at all. If your lordship will kindly remember,
No, the government will say the
private respondent himself said, my lord, he has not raised any bill till now.
Mr. Pandey will also try to obtain, shall also obtain photographs of the site and hand over copies thereof to the parties as well as tender a set for consideration of the court.
Obliged.
That's only request. Only request, my lords, I may be permitted to appear through VC on the 12th.
You know, we have said everybody will appear, BC.
Yes.
Learned counsel are allowed to continue submissions virtually on the next date of hearing.
My lords.
All right, take it out. Learned counsel are allowed to continue submissions virtually.
Obliged, my lords.